I thought I was buying a new car, but it was used. The salesman lied to me. What can I do? Well, that's not nice. A car salesman shouldn't be lying to you about what you're buying.
You want to do it?
What's your recourse?
I mean, first thing that comes to mind is a cause of action for fraud. If they're misrepresenting something to you, and legally it's misrepresenting a material fact, I would say that's a material fact in this case.
Absolutely.
You think you're buying a new car, you probably paid for a new car. You find out it's a used car, it's worth less probably than you paid for. And then if you rely on that, which sounds like you did in this case, then you've got a cause of action for fraud. So that's the first thing that comes to mind.
Shouldn't be a hard thing to prove. I mean,
No.
Can a good mechanic tell you that this car has a lot of miles on it, even if they tampered with the odometer somehow?
And that's probably what happened is they took it to get some work done, or they knew what they were looking at and opened the hood and said something's up here.
Yeah. But I do have one caveat for him.
Okay.
And that is go check that paperwork, because if they slipped it in on you by telling you it's a new car, and then on that paperwork it shows it's not, then you got a problem.
If it's got an odometer reading of 12,000 in a paper you signed,
that's
you
right.
got a problem.
Because the Supreme Court has said, as Blake was saying, normally you're justified in relying on what they say, but the Supreme Court of Alabama has said several times that if it's in that paper, you're not justified in relying. So got to check that paperwork too.
And we run into this a lot in insurance situations. We'll have people call us and say, hey, 30 years ago I bought this insurance policy and I've been paying my premiums. Now they say I owe this, or I don't have any money left. And we get the policy, and what they tell us, the agent told them, that's not what the policy says. And so what the Supreme Court has said, and it applies to the insurance situation,
the policy says.
If you were given that policy, then it's assumed that you read the policy, and legally you're now held to the fact that you have it and that you've read the terms. And so you've got 2 years then. So if 3 or 4 years later you say, oh, that's not what they told me, it doesn't matter, now it's too late.